As the Chief Justice of the Republic of South Africa and head of the Judiciary of South Africa, it gives me great pleasure to be part of this special gathering on this very special day, our Judiciary Day, and to present on behalf of the judiciary of this country its 5th annual Judiciary Report. The first annual Judiciary Day took place in 2018. The second one took place in 2019. I am particularly pleased that we have been able to have an in-person gathering such as we have today, because the 2 past Judiciary Days happened during the period of COVID-19 restrictions, which did not permit us to meet in the great numbers we see today, and were consequently held virtually. This was after COVID-19 had spread throughout the world, including our own country, and a national lockdown had been instituted. Before I go further, I wish to take this opportunity to thank the Judicial Accountability Committee, which is led by the Deputy Chief Justice, which worked very hard to ensure that we have Judiciary Day, and which made sure that we have the report that we are going to present today. I also wish to thank the leadership of the Office of the Chief Justice and all officials in the Office of the Chief Justice, who also worked extremely hard to make sure that the report that we present today is prepared, and who have made sure that all planning that was necessary for this day to happen, happened. I just want to make sure that you all know that your hard work is appreciated. But I also want to thank all of you who have taken your time to be with us on this special day. And thank you that you are here to join us on our Judiciary Day. Judiciary Day is an important annual occasion on the calendar of the South African judiciary. It is on Judiciary Day that through the Chief Justice, as the head of the judiciary of South Africa accounts to the people of South Africa for the performance of its judicial functions. Section 55(2) A and B of the Constitution place an obligation on the National Assembly to provide for mechanisms to ensure that all executive organs of state in the national sphere of government are accountable to it, and to maintain oversight of the exercise of national executive authority, including the implementation of legislation, and also to maintain oversight of any organ of state. Section 92 of the Constitution deals with the accountability and responsiveness of the President and his or her ministers for the exercise of executive functions entrusted to them. Section 92(2) of the Constitution provides that members of the Cabinet, which includes the President but excludes deputy ministers, are accountable collectively and individually to Parliament for the exercise of their powers and the performance of their functions. Section 92(3) requires members of the Cabinet to act in accordance with the Constitution and, more importantly for our purposes today, to provide Parliament with full and regular reports concerning matters under their control. Section 93(2) ensures that ministers are also accountable to Parliament. Deputy ministers are also accountable to Parliament for the performance of their functions and the exercise of their powers. There are no similar provisions in the Constitution in respect of the accountability of the judiciary to Parliament or to the executive in respect of the performance of its judicial functions. This does not mean that the judiciary does not need to account for the performance of its judicial functions. Indeed, we take Section 165(2) of the Constitution, read with subsection 6, as providing the constitutional basis for the Judiciary Day and for our annual judiciary reports, through which we account to the public of South Africa for the performance of our judicial functions. Section 165(2) of the Constitution provides, and I quote, "The courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice," close quotes. Section 165(6) of the Constitution places upon the Chief Justice, as the head of the judiciary, the responsibility for the establishment and monitoring of norms and standards for the exercise of the judicial functions of all courts. In respect of the superior courts, the Chief Justice exercises this responsibility with the assistance and support of the heads of court, which are the President of the Supreme Court of Appeal and Judges President of the High Courts and various provincial divisions of the High Courts and Specialist Superior Courts. In respect of the lower courts, the Chief Justice exercises this responsibility with the assistance and support of the Judges President of the various provincial divisions of the High Court, the Regional Court Presidents, the Chief Magistrates, and other members of the leadership of the regional and district courts. Therefore, the holding of Judiciary Day and the presentation of the fifth annual Judiciary Report are the results of collaboration and cooperation among various structures within the judiciary and the support from the leadership of the Office of the Chief Justice and other officials of that office. The holding of annual judiciary days and the release to the public of annual judiciary reports constitute irrefutable evidence that the judiciary unequivocally and unconditionally embraces the notion that it must account for the exercise of its judicial functions. What is the scope of the performance of judicial functions covered by the annual judiciary report? The scope of the annual judiciary report that I'm presenting today, excuse me, like its predecessors, covers only the following matters within the judiciary's performance of the judicial functions. A, matters finalized by each superior court assessed against the targets fixed in relation to each superior court. B, delivery of reserve judgments against targets set for the delivery of reserve judgments and the reduction of criminal case backlogs. The first two features of the scope of the report apply to all courts whereas the last one applies to criminal courts both at high court level as well as at the level of magistrates' courts. I will deal later with other features of the assessment of the judiciary's performance of its judicial functions, which do not fall within the scope of the annual judiciary report, but which are nevertheless important. For now, it is therefore appropriate to share with you some of the important information in the report concerning the judiciary's performance of its judicial functions. The fifth annual judiciary report provides an overall picture how the superior courts performed their judicial functions during the period under review. And the period under review relates to the 2021/2022 financial year. The annual judiciary performance plan indicators for the judiciary, as reflected in the annual judiciary report 2020/2021, remain relevant for this reporting period. The AJPP defines and identifies performance indicators and targets for the various courts. The performance indicators and targets are measures that allow for the monitoring of performance on one or more aspects of the overall functions and mandate of the judiciary. For the period under review, 10 of 13 performance targets were achieved. This represents a 77% achievement. Only 3 performance targets were not achieved. Those relate to the percentage of competition appeal court cases finalized, the percentage of land claims court cases finalized, and the reduction percentage of criminal case backlogs, and the reduction percentage of criminal case backlogs. Let me talk about finalized matters. All the superior courts fixed targets for matters that they would finalize during the period under review. The targets that the superior courts fixed for themselves and what they achieved or failed to achieve are reflected as follows in respect of all superior courts. The Constitutional Court fixed a target of 70%. In other words, its target was that it would finalize at least 70% of its matters during the period under review. And it did achieve that target and finalized 70% of the matters it dealt with during the period under review. The Supreme Court of Appeal fixed for itself 80% as the target of appeals that it would finalize during the period under review, and it achieved that target by finalizing 80% of appeals during that period. It fixed for itself 80% as the target for its applications or petitions, and it achieved that target as well. The Labor Appeal Court fixed 80% for its appeals as the appeals that it would finalize, it achieved 85% of appeals. In respect of applications, it fixed for itself 90%, and it succeeded in doing 100%. Criminal matters finalized in all divisions of the High Court. All divisions of the High Court fixed for themselves 75% of criminal matters, and collectively, all divisions exceeded that target and achieved 89%. The various divisions of the High Court fixed for themselves 64% of all civil matters as matters that they would finalize during the period under review, and they exceeded that target and achieved 88%. The Labor Court fixed for itself the target of 58% to finalize all matters that came before it during the period under review, and it achieved 60%. The Electoral Court had fixed for itself 90% of the matters that come before it as the matters that it would finalize, and it finalized 100% of the matters that came before it. The Competition Appeal Court fixed for itself 85% of the matters that would come before it during this period as the target that they wanted to achieve, but they were unable to achieve it and only finalized 50%. The Land Claims Court had fixed 60% as the target of the matters that they would finalize within the period under review, but they were unable to reach that target and only achieved 49%. It will be seen from this that the overwhelming majority of the superior courts performed excellently. They either reached their targets or exceeded their targets. It will also be noted that although the courts fixed their own targets, generally speaking, they fixed very high targets for themselves. Very often, they fixed 70% and above, and they mostly achieved those targets or exceeded them. Only 2 of the superior courts did not fare well in this regard: the Competition Appeal Court and the Land Claims Court. The Competition Appeal Court, as already indicated, achieved 50% instead of 85% that it had fixed for itself, and the Land Claims Court achieved 49% instead of the 60% it had fixed for itself. The Competition Appeal Court has ascribed its failure to achieve its target to the fact that it struggles to get High Court judges to sit in the Competition Appeal Court when it needs them. This arises from the fact that the cases heard by the Competition Appeal Court are not enough to justify that the High Court judges who would perform duties in that court should spend a whole term in the Competition Appeal Court, and therefore they've got to be asked to come and perform duties in the Competition Appeal Court as and when there are enough cases or there are cases to be heard. This system has proved to be problematic for the Competition Appeal Court, but the Competition Appeal Court has recently got a new judge president. For quite some time, it had acting judges president. It has a new judge president, and a new way has been found that will hopefully address this problem. And hopefully, next time, the performance that we will see from the Competition Appeal Court will be an improved one. The Land Claims Court is another court that did not do well. The Land Claims Court faces a number of challenges. The Land Claims Court faces a number of challenges. One of them is that for more than 10 years, it has not had a permanently appointed judge president. Its most senior judge was appointed acting judge president around 2011 and has been acting in that position since then. There is uncertainty about the court because there is a bill that has been pending for a long time that was initiated by the Ministry of Justice and Correctional Services, which seeks to bring about certain changes in the Land Claims Court, but has not yet been passed into an act. But COVID-19 restrictions also seriously affected the performance of the Land Claims Court during the period under review, because the judges of that court could not travel to hear cases that could not be heard virtually. And this accounts for a large portion of the Land Claims Court difficulty in achieving its target. It will also have been seen from what I've said above that there must be a lot of room for improvement in the performance of the Labour Court. It set for itself a target of 58% and achieves 60%. That court needs more posts to be created for judges in order to cope with its workload. In fact, as of October last year, it was not able to set down any matters for hearing or trial until 2024. That is an unacceptable situation, but it is because the court needs more judges and more courtrooms. This is a matter which has been discussed with the executive, and they are the ones who need to make decisions concerning the creation of more posts for judges and making available more courtrooms. It is not acceptable that matters, particularly labor matters, are subjected to long delays before they are adjudicated. It is hoped that the executive will resolve these issues soon. A reduction of criminal case backlogs. Excuse me. With regard to the reduction of criminal case backlogs, the various divisions of the High Court had fixed 30% as their target, to which they would reduce backlog. However, collectively, they failed to achieve this target and managed only 49%. On this, they did not do well. It is hoped that in the future, they will do better. Reserved judgments. As far as reserved judgments are concerned, collectively, the superior courts had fixed 70% as their target for the handing down of judgments reserved during the period under review. They succeeded in handing down 75% of the judgments reserved during the period under review, thus exceeding their target by 5%. Let me now come to some of the courts, starting with the Constitutional Court. During the period under review, a total of 385 cases out of a total of 554 were finalized by the Constitutional Court. The performance for the reporting period is in line with the set annual target of 70%. This is an improvement of 9% compared to the achievement percentage of 61% recorded during the previous reporting period. The total number of matters dealt with by the Constitutional Court increased by 24% from 445 matters during the 2020-2021 financial year to 554 matters during the 2021/2022 financial year. Let's look at the Supreme Court of Appeal. During the period under review, the Supreme Court of Appeal completed 194 out of a total of 242 appeals. This was 80% of the appeals. The SCA achieved the target of 80% it had set for itself. The Supreme Court of Appeal finalized 1,075 applications/petitions out of a caseload of 1,113 applications/petitions. This was a 97% achievement. It seems that an earlier reference to the performance of the Supreme Court of Appeal in relation to applications and petitions may have been inaccurate. I think this is the accurate figure. They achieved 97%. This means that the SCA exceeded its set target of 80% by 17%. Compared to the previous year, the SCA managed to exceed the set target of 80% during both reporting periods by finalizing 1,082 applications and 1,075 applications and petitions, respectively. Specialized courts. During the period under review, the Labour Appeal Court finalized 78 appeals out of a total caseload of 92 appeals. This is an achievement of 85%. The LAC exceeded its annual set target of 80% by 5%. The Labour Appeal Court completed 152 petitions out of a total caseload of 152 petitions. This was 100% performance. It means it exceeded its target of 90% by 10%. The Labour Court completed 2,580 matters out of a total of 4,307 matters. This represents a 60% achievement. This means that it exceeded the set annual target of 58% by 2%. It also represents an improvement of 8% to its performance recorded for the previous reporting period. During the period under review, 3% more Labour Court matters were received, whilst 18% more matters were finalized. The Labour Court sits mainly in 4 locations, namely Durban, Gqeberha, Cape Town, and Johannesburg. The caseload increased in 3 of the centres, namely Johannesburg, Cape Town, and Gqeberha. There was no increase of matters for the Durban Centre of the Labour Court. Matters finalized in the various Labour Court centres have increased by 38% Gqeberha, 37% Cape Town, and 26% Johannesburg. A decline of 23% is noted in the number of matters finalized by the Centre in Durban, which can mainly be ascribed to resource constraints. The Land Claims Court completed 98 matters out of a total of 201 matters, which represents the 49% referred to earlier. And this is an underachievement of 11% against the set annual target of 60%. This is due to the fact that the work of the court was severely hampered by the combined impacts of COVID-19 pandemic and the other matters that I referred to earlier. The Electoral Court only had 13 matters, and it finalized all of them. This represents the 100% I referred to earlier. The Competition Appeal Court finalized 3 matters out of 6 matters that it had, and this represents the 50% that I dealt with earlier. Then there is the reduction percentage of criminal case backlog in all the divisions of the High Court. The judiciary is committed to the reduction and ultimately elimination of backlogs in the various courts. The reduction percentage of criminal case backlogs refers to the percentage by which it was intended to reduce the case backlog during the period under review, and the percentage by which the case backlog was actually reduced. The annual target for all superior courts is set at 30% and mainly aims to ensure the finalization of criminal matters within 12 months from the date of the accused's first appearance in the High Court. At the end of the period under review, the total number of outstanding criminal cases in the various divisions of the High Court was 917, whereas the total number of backlog cases was 453, which represented a backlog percentage of 49%. The performance during the reporting period is therefore an underachievement of 19% against the set target of 30%. Compared to the previous reporting periods, the number of outstanding criminal trials increased by 5% compared to the 870 outstanding trials and 28% in the criminal case backlog compared to the 353 reported criminal case backlog. The reason for this increase is ascribed to logistical challenges, mainly the continuous load shedding, which has had an adverse impact on the operations of our courts. Compared to the previous reporting period, the number of outstanding criminal cases increased by 5% compared to the 870 cases outstanding and 28% in the number of criminal case backlog compared to the 353 reported criminal case backlogs. This increase is also ascribed to challenges, mainly to the continuous load shedding, which continues to have an adverse impact on the operations of our courts. It should be noted that in order to successfully attain the indicator on backlogs, the percentage of backlogs should be less than the annual target of 30%. This target was achieved only by the Eastern Cape Local Division of the High Court in Bishop and the Western Cape Division of the High Court. Percentage of criminal matters finalized. During the period under review, the various divisions of the High Court managed to finalize 9,853 criminal matters out of a total of 11,098 criminal matters, which represents 89%. The annual target of 75% was exceeded by 14%. Excuse me. Compared to the previous reporting period, a marginal reduction of 3% is noted in the total number of criminal matters, that is 11,098, compared to the 11,413 reported during the previous financial year, whilst an increase of 1% is noted in the total number of criminal matters finalized. From the above national overview, it is evident that the majority of the divisions of the High Court managed to achieve the set annual target of 75%, with the exception of the Eastern Cape Division, Mthatha, Eastern Cape Local Division, Gqeberha, Gauteng Division, Pretoria, Gauteng Local Division, Johannesburg, KwaZulu-Natal Division, Durban, and Limpopo Division, Thohoyandou. The reason for this underperformance is ascribed to logistical challenges due to the continuous load shedding. The highest percentage was achieved by the Free State Division, Bloemfontein, 97%, followed by the Western Cape Division, 96%, and the Limpopo Division, Polokwane, 8%. The Gauteng Division achieved 62% performance, which represents 13% below the target of 75, and can mainly be ascribed to the complex nature of the cases that the courts have to deal with, coupled with the multiple accused persons involved in many of the cases. Percentage of civil matters finalized in all High Court divisions. During the period under review, a total of 104,231 civil cases were finalized out of a total of 118,575 cases. This represents an 88% performance by all divisions of the High Court against the set annual target of 64. This means that the target was exceeded by 24%. During the period under review, all the divisions of the High Court achieved or exceeded the set annual target of 64%. Compared to the previous reporting period, an increase of 43%, 35,495. Performance is noted in the total civil matters finalized. The total number of civil matters finalized increased by 49%. That is 34,323. High percentages were maintained by all High Court divisions, with the Gauteng Division of the High Court achieving the highest percentage of 93%. Both the Mpumalanga Division and the Gauteng Division achieved very good results. The Mpumalanga Division achieved 92%. Percentage of reserved judgments finalized in all superior courts. During the period under review, a total of 4,070 reserved judgments was delivered within 3 months from the date on which they were reserved. This was out of a total of 5,463 judgments delivered, which represents an achievement of 75% performance. The target of 70% was therefore exceeded collectively by all superior courts. Compared to the previous year, the total number of reserved judgments delivered increased by 19%, that is 853 more judgments, while the number of reserved judgments delivered within 3 months increased by 14%, that is 481 more judgments delivered within 3 months. The highest percentage in delivery of reserved judgments within 3 months is recorded in the Labor Appeal Court, whilst the Constitutional Court achieved 8% in the delivery of reserved judgments within 3 months. The Constitutional Court delivered some of its reserved judgments after 3 months and others after 6 months. In considering the performance of the various superior courts in the handing down of reserved judgments within 3 months of the last date of hearing, it is important to bear in mind that it is easier for a judge who sat alone in a matter to hand down his or her judgment within 3 months than it is for a judge who sat with a number of other judges in a matter. When a judge writes a judgment in a matter in which he or she sits with 2 or 4 other judges, it may take longer to hand down the judgment because he or she must discuss and debate the judgment or the issues with other judges to persuade them to agree with his or her judgment. In the High Court, a judge normally sits alone, but will sometimes sit with 1 or 2 others. In the Supreme Court of Appeal, a judge will sit with either 2 or 4 other judges. In the Constitutional Court, a justice sits with 10 other justices with whom he or she must discuss and debate his or her judgment. And sometimes there might be more judgments in the same matter written by other colleagues, which also need to be discussed and debated. Those discussions and debates are important in order to try and achieve unanimous judgments, rather than a multiplicity of judgments in one matter, which may happen when there is no proper opportunity to discuss and debate issues among the justices. Furthermore, the justices of the Constitutional Court are always aware that the Constitutional Court is the highest court in the land, and there is no further appeal to another court if they give a wrong judgment. In each matter, they should seek to do all they can to ensure that each judgment they hand down is correct. Therefore, it is not surprising that there is a low percentage of reserved judgments that the Constitutional Court handed down within 3 months of the date of hearing. The Constitutional Court's performance concerning delivery of reserved judgments within 3 months must also be seen against the increased jurisdiction of the court. The court is the apex court and the court of final appeal in all matters. The 17th Constitution Amendment resulted in a significant increase in the workload of the court. Despite this increase in the jurisdiction of the court, the judicial establishment remained the same, thereby placing increased pressure on the justices to ensure that quality justice is achieved. The importance of judgments that are handed down without undue delay remains something that the justices of the Constitutional Court are alive to. Regional courts, criminal court performance. For the period under review, regional courts utilized a combined total of 63,913 court days, a combined total of 171,349.10 court hours, a total of 40,771 new cases were registered, a total of 41,927 cases were disposed of by the regional courts. The performance of the regional court divisions can be summarized as follows. Average court hours, 2 hours 40. This is below the set norm and standard of 4 hours 30, but the combined hours of both criminal and civil matters adds up to 4 hours and 42 minutes. Average clearance rate, 103%. Though most courts are able to keep up with the incoming new cases, this is not the position in all regional courts, which indicates that additional courts are needed to deal with the increase in the workload. Finalized cases per day, 0.28. Cases disposed of per day, 0.67. Cases enrolled per day, 2.38. Throughput, 9 hours 25. Cases in the regional courts seem to take much longer to finalize, which may be indicative of the increasing complexity of cases in the regional courts. A comparison between the current financial year or the period under review and the previous financial year indicates that the court days increased by 8%, new cases increased by 9%, and cases that were disposed of increased by 20%, and the court hours increased by 18%. It should be noted that the 2020-2021 period fell during the hard lockdown that impacted severely on the ability of courts to function. Regional courts civil performance. For the period under review, the regional courts utilized a combined total of 11,827 court days and a combined total of 24,069.13 court hours. In respect of civil matters, the performance of the regional court divisions can be summarized as follows. Average court hours, 2 hours 2 minutes. This is below the set norm and standard of 4 hours 30, but the combined hours for both criminal and civil sittings adds up to 4 hours 42 minutes. It should be noted that many regional courts are doing both criminal and civil cases on a daily or weekly basis, with only a few regional courts doing civil cases. Finalized civil applications per day, 1.15. Finalized civil trials per day, 2.19. A comparison of the current financial year of the 2021-2022 financial year with the previous financial year indicates that the court days increased by 42%, enrolled cases increased by 13%, finalized cases increased by 18%, and the court hours increased by 39%. Case flow blockages, stroke challenges. A number of factors contribute towards case flow blockages, which entails the unavailability of stakeholders, the unavailability of courtrooms, defective court recording equipment and intermediary systems, load shedding, natural disasters, and bad and adverse weather conditions, among others. With regard to reserved judgments in the regional courts do not reserve judgments for longer than 3 months. District courts. The collection and collation of the performance of information of the magistrates' courts relies on the integrated case management system for the Department of Justice and Constitutional Development. In September 2022, the heads of the administrative regions of the district courts resolved that as a result of the system failure caused by an ICT security breach in the Department of Justice and Constitutional Development, the performance information for the reporting period in relation to the district courts would not be published because it was not accurate. The heads of superior courts supported this decision as the veracity of the information could not be tested. It will be remembered that in the previous judiciary report, we had the same situation in relation to the district courts. We did not have information relating to their performance, and it was for the same reason that we have today. I hope that the Department of Justice and Constitutional Development is going to attend to this so that next time when we have our Judiciary Day, we don't have a repeat of this and we have information, reliable information relating to the performance of district courts. Let me touch on judicial education and training. In the period under review, SAJ conducted 168 courses, exceeding the planned target of 105. This success is attributed mainly to the innovation in virtual platforms. However, ad hoc requests from the leadership of the judiciary for additional training sessions increased during the reporting period. In an effort to ensure that there are no disruptions to court proceedings, some of the webinars were conducted after working hours to allow judicial officers to focus on court work. In celebration of SAJ's 10th anniversary, SAJ, of course, is the South African Judicial Education Institute. In celebration of SAJ's 10th anniversary, an international webinar on judicial training was arranged and attended by 125 participants from African and international countries. The overall objective was to discuss the link between judicial training and judicial performance through the lens of the International Organization for Judicial Training Principles. This highlights the importance of judicial training using participatory training methods as well as cooperation and collaboration of regional and international judicial education institutions. To commemorate the 10th year anniversary, SAJ is publishing a book on judicial education in Africa. There was a 33% increase in the total number of participants compared to the 3,297 participants in the previous year. Furthermore, during this reporting period, a total of 148 newly appointed district magistrates attended virtual training sessions. It should be noted that the course content was expanded to include judicial wellness, gender-based violence and femicide, equality court skills, and illegal wildlife trade. To enhance contributions towards SAJ Journal, newsletter, and book on judicial training in Africa, judges and magistrates attended virtual writing skills training conducted by JUTA. It will have been seen from what I've said above that the 5th annual judiciary report reflects that the 2021-22 financial year, during the 2021-2022 financial year, the superior courts performed very well in regard to some of the matters on which their performance was assessed. Most performed to an average that is above 70%, and by any standards, that is very good performance. In those areas where the judiciary has done very well, I wish to thank all judges and all judicial officers for their hard work and dedication. In those areas where we have not done well, I want to encourage all members of the judiciary at all levels that we rededicate ourselves to working even harder in order to ensure that we improve our service to the public. Although we do not have the performance information for the district courts for the reason given earlier, I want to take this opportunity to acknowledge the importance of the judicial work done by the judicial officers in the district courts and regional courts, but particularly in the district courts, because those are the courts which ordinary South Africans interact on a daily basis when they seek justice. It is therefore vitally important that the judicial officers in those courts do all they can when they do their work to ensure that the people who find themselves in those courts are treated with courtesy and their human dignity is respected at all times. If judicial officers ensure that people find justice and respect in those courts, that will go a long way to giving hope to those people and to giving those people a positive image of our courts. They must feel that these are their courts and that if they take their disputes to them, they will be treated with courtesy and respect. The superior courts have performed in the way they have performed, as reflected in the annual judiciary report that I'm presenting, despite the fact that the judges in those courts perform their judicial functions sometimes under extremely difficult conditions. Sometimes the buildings from which they operate are in conditions that are completely unacceptable. Sometimes the lifts in those buildings are not working, and it takes ages before technicians are sent to fix the lifts. Sometimes they carry huge loads of work because there is a need for more judges to be appointed, but for one reason or another are not appointed, or it takes too long to have them appointed.